Today on Connecticut Yankee Sanity, we'll talk about the judiciary branch of the federal government. In a few short clauses, Article 3 of the Constitution established the federal court system, including a Supreme Court to hear cases not resolved in the lower courts. Alexander Hamilton, himself a lawyer, wrote no fewer than 6 Federalist essays on the subject, which gives us an idea of the court's importance to the framers. In the Federalist number 78, published in May of 1788, he argued that the courts should be confined to judging. Furthermore, they should be weak in the sense that they were not to have political or legislative power. Legislating from the bench, in other words, was foreseen, as was so much else, by the framers, and they wanted safeguards against it. Political influence being exerted on judges also concerned them. Hence, judges were to be appointed to serve during good behavior, quote unquote. The phrase was and is understood to mean to serve for life as long as judges minded their P's and Q's. In that way, they weren't dependent on having the right political ideology in order to retain their appointments. The wording both reassures and cautions. A judge has a lifetime appointment, but in the absence of good behavior, he can be impeached, and if convicted, removed. In 230 years, only 6 judges have met that fate. John Pickering was the first in 1804 for drunkenness and unlawful rulings. He staggered back to New Hampshire and died the following year. The 6th removal in 1989 was Alcee Hastings on bribery and perjury charges. Hastings fared better than Pickering. Not only did he not meet his maker, undaunted by his dismissal, he ran for Congress in 1992 and served for 20 years as the representative of Florida's 23rd District. I love happy endings, don't you? But not so fast. The Democrats, having recently disgraced themselves savaging Justice Kavanaugh during his confirmation hearings, had another crack at libeling him early this month. This latest smear necessitated an apology from the New York Times, but congressional Democrats howled for his impeachment anyway on an unsubstantiated allegation that he engaged in lewd behavior during a college party 30 years ago. Justice Kavanaugh denies it, and the supposed victim doesn't recall its ever having happened. But so what? It's a particularly egregious example of what the framers of the Constitution earnestly wanted us to avoid. The Democrats are harassing the man. If we fail to destroy your life and reputation during your confirmation hearings, they're saying, don't think you're home free. We'll hound you even after you're on the bench. But why? To warn off future Trump administration nominees. In this instance, if I'm right, they're hoping to hobble the nomination and confirmation process should the failing Ruth Bader Ginsburg exit before Joe Biden can win his fantasy victory against the Trumpster in 2020. Such politicization is, unfortunately, nothing new. Politics has been present in the judiciary from the beginning. We started off with 6 Supreme Court judges during the early Federalist period, but in the final days of the administration of John Adams, our second president, Congress passed the Judiciary Act of 1801, which reduced the number of judges to 5. On his last day in office, Adams appointed 23 lower court judges, with men mainly from his own Federalist Party. The actions ticked off incoming Democratic Republican Thomas Jefferson right to the roots of his red hair. He made sure he got the last laugh by refusing to confirm 11 of the appointments, signing repeal of the Judiciary Act of 1801, and eventually increasing the number of justices on the Supreme Court to 7. Since Donald Trump took office, politicization has intensified, and not because the Trumpster has packed the courts with reactionaries. It's the left's judge shopping to find liberal lower court judges who will issue rulings that hinder the president and his administration. This past July, for example, Seattle District Judge Marcia Peckman issued a nationwide injunction putting a hold on Attorney General William Barr's order that U.S. authorities deny bond hearings to illegals making asylum claims inside our borders instead of in Mexico or a third country. This at a time when the United States is being invaded by millions of illegals, virtually all of whom claim asylum, get processed, and then flee to a sanctuary city and disappear. Injunctions like Peckman's are issued knowing they'll be overturned by the Supreme Court. The intent is to thwart the executive by frivolous obstruction causing delay. That such injunctions run counter to the intent of the framers is clear. The courts were not meant to decide, quote, questions in their nature political, unquote, or to force the other branches of government to act politically as decreed by the courts. The framers, in fact, specifically rejected a proposal that a council of revision be established that would have given the courts the power to oversee the executive branch and to exercise a veto or revise laws. So, if the courts can't be entirely free of political bias, is it better that the judges be liberal or conservative? Now, here comes the hard part for liberals to swallow. The founders were conservative, which in the liberal mind tends to mean hidebound and hopelessly unprogressive. The conservatism of the founders, however, consisted in their desire for order, stability, and safeguards against the weaknesses of human nature. It was not meant to annoy future leftists like Elizabeth Warren or Bernie Sanders. Change, when it occurred, the framers believed, should be gradual and well thought out, not radical and precipitous. Above all, they did not wish for the judicial branch to make laws or influence public policy. They wanted it to uphold and enforce the Constitution and the laws passed by the legislature and approved by the executive. It was not the intent of the framers that the courts obstruct the president when exercising powers granted him by the Constitution. William Barr recently called upon lower court federal judges to stop obstructing the president in his effort to secure our southern border. He was doing no more than asking them to respect the Constitution. The viewer will not fail to appreciate the irony. In regard to the law, it is best that our courts be conservative. That doesn't automatically mean, as liberals would like us to believe, that a woman's right to an abortion will be overturned or that men will no longer be allowed to marry other men. It means that the courts should confine themselves to rulings on the law and stay out of politics. The best, most conservative judges do that, which benefits liberal and conservative citizens alike. Our politicians would be well advised to respect the law themselves and not use the courts for political ends. Given the unprecedented hatred and vindictiveness manifested by the left these days, however, I wouldn't advise you to hold your breath. Thanks for watching. Be sure to click like and subscribe to support the channel and pass the link along. We'll see you back here next time.